This is the ruling of the court. The Directorate of Criminal Investigation as the applicant versus the 8th respondent. Dan Adero Okoth, Emmanuel Mutuku Madheka, Nicholas Makuna Muyela, Livingston Ambai Munala, Kennedy Mulatia, Paul Muigai Kimani, Leonard Clifford Wafula, Safaricom Kenya Limited, Airtel Kenya Limited, that was as for the first application. The second application was for Dan Adero Okoth, Emmanuel Mutuku Madheka, Nicholas Mukuna Mayela, Livingston Ambai Munala, Kennedy Mulatia, Paul Muigai Kimani, Leonard Clifford Wafula, Patrice Josiah Tumbo. This application is brought via the notice of motion dated 1st of April 2025, filed by the DCI through the prosecution. The application is presented or expressed or brought under the Articles 26, 47, 48, 49, 1F and G, and Article 50 of the Constitution under Chapter 4. It has also been brought under Section 36A of the Criminal Procedure Code. It has also been brought under Section 317, 351, 345 as read with Section 349, Section 101 and Section 127 of the Penal Code Laws of Kenya. The application is supported by the affidavit of number 80936, Detective Sergeant Nicolaus Osuri Otieno from the DCI. At the hearing of the application, the prosecution counsel did invite the investigating officer to make a remark. In their submissions by the prosecution counsel and the DCI, they were urging the court that the application that is before this court is that the respondent's hearing should not be released or admitted to bail pending investigations. The investigating officer took the stand and swore and stated that he relied on his affidavits and stated that there were compelling reasons which he took the court through to warrant the 8 respondents to be detained pending further investigations. He stated that they were pending completion of investigations which he required to trace more witnesses for purposes of recording witness statements, to obtain relevant reports from forensic experts, from Safaricom and other agencies. He also stated that the nature of the charge under investigation and the strength of the evidence so far collected also warrants the court not to release the accused persons, since they may interfere with the investigations or the witnesses. He also stated, referring to the paragraph 2 of his affidavit, that he intends to charge the respondents with the forgery of stamps and documents, making of false documents, conspiracy to defraud, obtaining registration by false pretense, uttering false documents, abuse of office, fraud and breaches of trust, among other offenses under the Penal Code. On compelling reasons, he stated that as per the application he had made, he has so far complied with order number 126 which he was seeking for search warrants to which have already been complied, and that an inventory has been filed as paragraph 9 of the affidavit. He also stated that in the course of the investigations, they did recover documents which has been referred in the affidavit paragraph 9, which include land registration documents, to wit, certificate of titles, leases, title deeds, transfer of interests in land, letters of allotment, forgery of stamps, seal stamps, mobile phones which are subjected to forensic analysis by the government printer, the forensic document examiner, and the digital forensic unit DCI, National Forensic Laboratory, to determine their authenticity and their originality. From the affidavit that has been sworn, that there were stamps which had imprinted names of county government of Kiambu and Nakuru, including stamps of advocates, land registrars, land and physical planning, among others. He also stated on oath that investigations were still ongoing, such as were conducted in the homes and offices of the respondents herein, and that they will require to trace witnesses from the documents required and record statements. They urge the court to consider the serious nature of the offenses and the fact that the witnesses are likely to interfere with the witnesses and scuttle the investigations if Gary Kimani, Leonard Dofula, Safaricom Kenya Limited, this application the prosecution presented or expressed or brought under the Articles 26, 47, 48, 49, and 27 of the Penal Code laws of Kenya. Of the application, the prosecution counsel did invite the investigating officer and stated that there were compelling which he took the court to warrant the 8 respondents to be detained. The investigations or the witnesses. He also stated, referring to the and documents, making of false documents, conspiracy to defraud, obtaining registration by false, which he was seeking for such warrants, which have already been complied, and that an inventory has been, which has been referred in the affidavit paragraph 9, which include land registration documents, to wit, certificate of titles, leases, title deeds, allotment. From the affidavit that has been sworn, that there were stamps which had imprinted names of county government of Kiambu and Nakuru, including stamps of advocates, land registrars, land and physical planning, and offices of the respondents hearing, and that they will require to trace witnesses from the documents, one having been one for the search and the second one for extension of time. Counsel concluded that the state had submissions read by Mr. Tito and added that there was a tendency if they are not detained. The prosecution submitted that due to the complexity of the investigation, the Office of the DCI would require more time to investigate each of the respondents together with the exhibits required, and as the consequence submitted that it would not be unreasonable to detain the respondents herein pending investigations. They sought for 14 days to have the 8 respondents be remanded in custody pending investigations. And in conclusion, the prosecution stated that the right to bail pending investigations was not absolute, and urged the court to consider the right of all parties and strike a balance by allowing their application. Submissions were made by the respondents' counsel, Mr. Keaton, for the second and fifth respondent, I believe, took the stage and made detailed submissions, which I'll make an effort to try and summarize. That there are two silent issues guiding the court on how the application should be canvassed, and that the first one was whether the notice of motion is merited and whether there are compelling reasons. Relying on the law and authorities submitted, counsel submitted that the affidavit as from the affidavit of the IO, further investigations that are to be done do not require the presence of the respondents. He also stated that the judicial notice that had been referred by the investigating officer in his affidavit is not a matter of public notoriety, and that the court should not detain the respondents over the same. He also submitted that the fourth respondent, being a police officer, no evidence of interference of witnesses has been placed before court, and that the averments by the IO is bereft of any merit or substance and must have not met the threshold. He also relied on the law, specifically Section 36 of the CPC, and stated that court should not detain persons unless there are compelling reasons, and stated that if the court is in doubt, can impose certain conditions on the respondents that can be complied with. He relied on the authorities of Danford Kabange Mwangi, Michael Rotich, and Kenneth Omondi Ochieng, and 38 others. On Danford Kabange, the same was on liberty of the accused person, which is stated that the same should be respected unless there are legal reasons. On Michael Rotich versus Republic, on the need of a holding charge to inform the suspects or respondents on what they are being charged of. And on Kenneth Omondi case, the court was invited to make a determination on the same. Another issue that counsel did raise was for the court to make a determination on whether it was proper for the prosecution to file two applications, the first one having been one for the search and the second one for extension of time. Counsel concluded that the state had sufficient time to investigate the matter since 29th of March 2025, and prayed that his clients be released on a cash bail of 20,000 each since they were young men. The second counsel was Mr. Mayodi, who also took the stand, reiterated the submissions made by Mr. Keaton, and added that there was a tendency of the state authorities to arrest suspects, then seek time to investigate, which was akin to putting the cart before the horse. He reiterated Article 49(1)(g) of the Constitution on compelling reasons, and submitted that the IO had not adduced compelling reasons, and that there was no holding charge. He also submitted that the third and the fifth respondents were family men whose wives were expectant, and that it would be fair if they are left to go and cater for their families. He also stated that the court be guided by the judiciary bail and bond policy, and balance the interest of the accused persons and preserve their liberty. Concluded by seeking favorable bond terms for his clients, and added that while referring to a medical report for the seventh respondent, and stated that he should be given a reasonable cash bail to be taken to a hospital facility for treatment and not be committed in custody. Mr. Bondi was for the 8th respondent. He also submitted that the court should safeguard the rights of the accused person, noting that the investigating officer has not stated why or how his client was arrested, and that the grounds that had been given no ground has been given as to how the 8th respondent will interfere with the investigations, and urged that the court also releases the 8th respondent on reasonable bond terms. Mr. Ndung was for the 7th respondent. He also reiterated the sentiments of his colleagues and submitted that the 7th respondent herein had a medical condition, hypertension, and produced a medical document in support of that argument. He also stated that what has been stated by the investigating officer is all circumstantial, that no good reason has been given to show why the respondents should not be granted a favorable cash bail, and that the 8th respondent has a fixed place of abode, which is Umoja Estate, and is not a flight risk, and that the investigating officer has made a wholesome application treating all the respondents the same, and that they should be treated separately. That they should be treated separately, with each having specific offenses and exhibits in their name. The 4th respondent was presented by Mr. Muriungi. He also affirmed submissions made by his colleagues and reiterated the authority of Kenneth Omondi, and stated that the application that is before court falls short of the threshold as determined by the said court on issues of criminal liability. He also relied on Section 36A of the CPC and Article 49H of the Constitution. He also stated that the investigating officer did not specify the intended charge of each respondent, that there is a highlight of nature of offenses, but the same has not been connected to each respondent. He also complained that the respondents herein were intentionally arrested on Friday to ensure holiday. Counsel also mitigated for the 4th respondent that he is a husband and a father to a 1-year-old who depend on him. Prosecution counsel denied on the allegations that the arrests were made on Friday deliberately, therefore denied the averments that the same was calculated to prejudice the accused persons. Holding charge, the prosecution counsel referred to the case of Michael Rotich, which had been referred by the defense, and stated the court and invited the court to go through the whole authority, and submitted that the holding charge, that the failure for the prosecution, there are other authorities which state that the court cannot, the prosecution, it is not a must for the prosecution to avail in court before the required 24 hours period. Issues that the court was to look at, the defense and the record in its entirety. It is clear to me that a single issue for determination is whether the state has sufficiently presented compelling grounds to warrant detention of the 8th respondents for the period sought. In my analysis, looking at what had been submitted, I will start with the compelling reasons. I did look at the law and the authorities. From the authorities that has been provided, it is clear that both the Constitution and the Criminal Procedure Code, as stated in many cases, does not define exactly what compelling reasons are, but what compelling reasons are. Various cases or courts have tried to interpret the same, and looking at the Black's Law Dictionary, the same is defined as extraordinary, beyond what is usual, customary, regular, or common. It defines it as a circumstance or an accompanying or accessory fact, event, or condition, such as piece of evidence that indicates the probability of an event. I did look at various authorities, and also Article 49(1)(h) of the Constitution, which provides an arrested person has a right to be released on bond or bail, reasonable conditions pending a charge or a trial, unless there are compelling reasons not to be released. The rationale behind the bail and bond in Kenya, I believe, is mostly premised on Article 52A of the Constitution, that the accused person is presumed innocent until the contrary is proved. The bail and bond application, on bail and bond applications, as per the law in Kenya today, all suspects have a constitutional right to be released on bail. This, being an inalienable right, can only be restricted by court if there are compelling reasons for him not to be released. Therefore, in granting bail and bond, the trial court is called upon to exercise its discretion, and if there are no compelling reasons to deny the accused person bail and bond, the trial court should exercise its discretion in favor of the accused. The court did look at a case of Kennedy Ochieng that had been submitted by the defense on instances or considerations that the court is to look at when determining issues of compellable reasons. The first one was the nature of the charges. The second one is the strength of the evidence which supports the charge, the gravity or the punishment in the event of conviction, the previous criminal record of an accused person, probability that an accused person may not surrender himself for trial, likelihood of an accused interfering with witnesses or suppressing any evidence that may incriminate him, the likelihood of further charges being brought against the accused person, the probability of guilty, detention and protection of the accused person, the necessity to procure medical or social reports pending final disposal of the case, any or a combination of the above, if proved to the required standard, that would be a basis to detain the respondents as per holding in the authorities. I did consider a case which is a case of Sudi Oscar Kipchumba versus the Republic, on also the issues of compellable reasons, what the court should consider as being parameters that have been set by the court. The court did look at the said authority, where the judge stated that even while accepting the text of Article 49(1)(f, in certain circumstances and context, comprehend a situation where a person presented before a court without being formally charged and is thereby informed of the reason of his continued intention through the state's application to have him so held, the state must satisfy a double test. The first test that the state must satisfy the court is that they must demonstrate that they are acting in absolute good faith and that the continued detention of the individual without a charge being preferred, whether provisional or otherwise, is inevitable due to existing special circumstances. The second test that the state must demonstrate that the continued detention of the individual without a charge is the least restrictive action it can take in balancing the quadruple interest present in a potential criminal trial, that the rights of the arrested persons, the public interest, order and security, and the need to preserve integrity of the administration of justice and the interests of the victim were appropriate. And by virtue of Article 21(1) and 259 of the Constitution, the court must act to grandize, not diminish the personal liberties of the arrested individuals in line with other interests. Differently put, the state must demonstrate that there are compelling reasons to deny bail and balancing all factors with the complex permutation presented by the quadruple interest without referring or essentializing any. Therefore, based on the issues of compelling reasons and based on the submissions that have been made by all the parties, the court finds that the prosecution have established compelling reasons to have the application allowed, that the offenses for which the respondents are under investigations are of great nature as listed in paragraph 2 of the supporting affidavit, that there is a likelihood that the respondents may interfere with the witnesses or the exhibits that may be of the evidence that may be against them or may incriminate them. It has also been stated that the exhibits were recovered from the homes and offices of the respondents herein. Therefore, to guard the integrity of the investigations, it would be prudent that the court considers that the application is allowed so that the investigations can be concluded. Having considered other matters that had been stated in issues of holding charges and others, the court also looked at the other authorities which the prosecution stated that the court should look at. The case of Betty Chemtai Meiwa, also submitted by the defense, the case of Chris Philip Obure versus Republic, Samuel Cheriot Arap Langat, provide contrary findings on issues of holding charges. Therefore, it is not a must that the prosecution avail a holding charge before court as long as the accused persons are provided or availed before court on that before the lapse of the 24-hour period. And also considering Article 49(1)(f) of the Constitution, the same does not make reference to a charge or a draft of a charge sheet, but provides that the accused person be availed in court at the first, in court on time at the first appearance, or to be released or to be granted bond on reasonable terms, or be informed of the reasons that of his continued detention. Therefore, I will be guided by the said authorities and find that there was no need for a holding charge. On issues of liberties and interests, parties had submitted that the court should balance the right. And the court did look at the international instruments together with our Constitution and the authorities. Everyone has a right to liberty and a security of person, and no one should be deprived of his liberty except on such grounds in accordance with such procedures as are established by law. Therefore, issues of liberties are not absolute where legal matters or rights are to be determined. The court finds that having satisfied that issue, the liberties of the accused person will not be prejudicial as investigations will be conducted. Court will give directions on how the same is to be conducted. Any matters that are arising or touching on the individual respondents, an application can be made by the respondents before court for determination on whether the applications that are properly before court, the investigating officer having filed the same in the same file. The court did peruse the said application. The first one arises out of a search and a warrant of arrest. The same has been effected. The second application seeks for extension of time. The court finds that the events being connected, which involves the same respondents and the parties herein and the same events, the application that is before court is proper, and therefore the same is allowed. Just for avoidance of doubt, having clearly considered the matter and that is before me and the court, I find that the application is merited. I proceed to direct as follows: that the 8 respondents shall be detained at Muthaiga and Ruaraka Police Station as the capacity may allow for a period not exceeding 10 days. I have taken into account the period that they have been in custody from the date of the arrest, and the period shall run beginning the 3rd of April 2025, being the date the application, subject of which the ruling is made, was heard, pending completion of investigations and a decision to charge respectively. Therefore, the matter will be mentioned on 11th of April at 9 a.m. before the duty court for further directions. This is the ruling of the court. The Directorate of Criminal Investigation of the applicant versus